This is the plaintiff, Justin Medeiros. He says he hired the defendant to move him from Massachusetts to Florida, and she botched the job and damaged his stuff. If that weren't bad enough, the truck she used wasn't big enough to hold all of his stuff, and he had to rent a truck himself and drive his remaining belongings to Florida himself. He's suing for $4,850. This is the defendant, Vanessa Gonzalez. She says she personally inspects all the stuff that comes to her warehouse on interstate moves. All of the plaintiff's things look fine, and he never complained about anything after his shipment arrived. Then, he files this lawsuit and states his whole shipment was destroyed. What a lie! She is accused of making some bad moves.
All parties, please use your right hands.
Welcome back to the People's Court. Next case on the docket, the plaintiff says he hired the defendant's moving company, but when it came time for the move, they brought a truck that was way too small. He ended up having to rent his own truck and then drive his stuff from Massachusetts to Florida. Now, the defendant says the guy lied about how many things he had to get a cheaper price. It's the case of nothing but bad moves.
Your Honor.
Thank you, Douglas.
You're welcome, ma'am.
Mr. Medeiros, you decided that you were going to move from where to where?
Massachusetts to Florida.
Good move. Where in Florida?
Cape Coral.
Okay. So when you make that decision, you have to hire a moving van to take your belongings from Massachusetts to Cape Coral. And how is it that you find the defendant's moving company?
So I researched them online by Google. I came across a broker company, and they quoted me a price of the inventory I had for $1,500. And
well, you're the one who tells them what you have, right? And
yes.
So
Yep.
what do you have any record of what you told them you had?
Yes, it's in a text
Okay,
message.
did you submit that into evidence?
I did. And that would be a text message from Paul. And it had my whole inventory and then what he was quoting me.
I have a 60-inch TV, an electric fireplace, large artificial plant, 3-seater couch, love seat, bed frame, mattress and dresser, end table, 2 large ottomans, a mower, a mirror, some wall decor. And so you're negotiating the price.
Mm-hmm.
And then they
Says he got me for a total of $1,499.90.
settle on $1,500. Now, according to you, Ms. Gonzalez, when your movers get there, it's not what he had stated on the list. It's significantly more. What else more was it?
So basically, when my guys show up at a home, as stated on the broker's contract, as well as ours, it goes by cubic feet or by pounds, however the broker decided to book the job and the contract. In his case, it's based off cubic feet. In this particular case, his items went up to 600 cubic feet. And that's all. There was more. There was more stuff, but I guess he decided that this was the max cap. And that's what we loaded, and that's what we took.
But what I don't understand is if the broker is your agent who books your stuff, and I tell them this is what I have, and they give me a price, what right do you have to then go to the homeowner's house on the day of the move and say, "No, your stuff weighs more than it should"? If it's by weight, the broker better be going over. Yeah, but now you got them hostage. You see, I know that people in his position are constantly underinflating. They always say, oh, it's just a few odds and ends and it's a lot more. But I also know that people in your position often then say, when you have a gun to their head because it's the day of their move, oh, no, it's going to cost you a lot more. So I'm trying to figure out where this falls in that continuum, right? So you guys get there and you guys tell him.
We give a revise before we touch anything.
You give him how many times, what percentage of your cases do you end up giving a revised at the scene?
Sometimes there's maybe 40%.
So you give him a revised contract, you tell him if you want us to move you, you got to pay us X. And all of a sudden it goes from $1,500 to what?
His grand total came out to $3,575. However, on his inventory list, on his original with the broker, he had 22 items and 40 pieces, and we loaded 70, 80, 90, 100.
Okay. So in any event, what ends up happening is you do agree to the different move price, correct? And in fact, even that truck isn't enough. You end up having to rent another truck to take all your stuff down. And you gave away a bunch of stuff, right, Mr. Medeiros?
Yes, Judge, and I'm gonna
Okay,
tell you why.
so if it's good enough for
Because
you, it's good enough for me. You have a new agreed upon price and you sign that. And then you even have more stuff you want to take because you turn around and you have to rent a vehicle. But what the real meat and potatoes here is not that you're suing for the added cost. You're saying they destroyed your stuff. So talk to me. Tell me what happened.
Yes, so they damaged a 60-inch Vizio TV.
Okay. How old was that TV?
It was purchased last year around the holidays, right after
Do
Thanksgiving.
you have a receipt for it?
I do not.
All right, so let's move on. What else? You've got here bureau leg. What happened? Your
Bedroom
bureau
set.
leg came off?
Yep.
Is that the footboard of the
centerpiece.
same bedroom set?
So
Is that the
it's
same bedroom set?
but it's three different pieces from it. So it's the headboard, the footboard, and the bureau legs.
Okay, and how old is this bureau set?
It's a little over a year old.
Do you have a proof of that? Because it looks older than that to me.
I do not have a receipt for that, no.
Okay, and then you're also claiming for the leather love seat. So let's see the things you're claiming. There's this scratch here. There's the erosion of bonded leather, because I can see that that's what it is. It's just the bonded leather. It's the pleather, basically, because it's just you know what bonded leather is? It's when they take all the little bits of leather and melt it together and then put it on top. It's not an actual hide. That, I recognize that peeling because I've had bonded leather, for years, where that happens, which is why I don't have bonded leather anymore. So tell me how that would be the mover's fault.
So on the inventory list, it states the conditions and everything that something is in, okay? And if you see on the conditions of the sofa, that's exactly all the damages that's listed from my foreman on the day of the pickup. That's the only thing that has damages out of all his inventory list. It's only the sofas.
What say you about that, Mr. Medeiros?
I'm looking at that she put. There was no damage to this. This is about a year and a half old. I'm still paying on it. It's not bonded leather. It's
That's
real leather.
lovely. You have no receipt for it, and I have evidence that they said it was completely damaged, and you signed the inventory list.
I have
why
a
would you
receipt.
sign
I
it
have
if
a
it says it
receipt
was
for it.
damaged?
I have a receipt for it.
Why would you sign the inventory list that says that the sofa was already damaged if it wasn't already damaged?
I have no idea, man.
I think I know why, because you don't want to have to pay this much for the move. That's why. But we've got an additional problem. Ms. Gonzalez, what did you ever, according to you, he never filed a claim, but according to him, he submitted it. Yeah, but he gave me a copy of a claim he submitted.
They never sent me anything, and I never heard from that man. And, when he claims that everything was damaged, he has my direct cell phone number. I am the owner of the company, and I'm very involved with all customers. Okay, that man never reached out to me since his delivery. And for somebody to have all these damages, the first thing you're going to do is call, especially that you have contact with me. Never.
Right, $4,850 worth of damages that you're suing for. Tell me, did you ever call the company?
Absolutely. I called the company. I talked to Jessica. I sent you the text messages.
Jessica is not my company. That's the broker.
Okay, tell me what happened, though. You spoke to the broker and what?
She said that she's very sorry about this and to go ahead with making a move claim. I sent a claim in.
Okay.
I actually even have the claim back. So to say I never contacted
Okay, and
them,
what happened with the
crazy.
claim?
The claim, they said that they want to give me $144.
Right.
Because that's a third party. That's not somebody in my office.
Okay, but you're saying that you
It
never
doesn't
heard from
really
them.
matter
I'm telling
much,
you that
folks. It is the claims management company for, how does this work? Are you a franchise, Ms. Gonzalez?
No, I'm not a franchise, but I do use a third party for my claims.
Now,
but this
what that says that he finds insulting is that they offer him $144. So you explain to me what the problem seems to be here.
So we have a form here, which all customers sign. Unless they purchase full coverage, they're only 60 cents per item per pound. That's what the state requires us to cover.
Mr. Medeiros, when you signed the documents, you are offered an opportunity to insure your stuff. And the contract that you signed gives you two options. Option one is you pay to fully insure your stuff. Option two is costs you nothing, which is your preferred price, But if something gets damaged, you are limited to 60 cents per pound. You picked option 2. You're insulted at $144. That's 240 pounds at 60 cents a pound. You tell me, why did you pick option 2, and now you are suing as though you had picked option 1, which would have cost you, let's see, I don't know, an extra $1,000, I guess, with a $500 deductible or $750 with a $1,000 deductible. Why is it that you did not insure your stuff and now you're complaining? Because you see, this is a contract. I didn't sign this contract, you did. You see?
Okay.
So in the contract, you waive your right to claim all these damages unless you cover yourself by paying extra for the insurance. You chose the cheaper version. By the way, almost everybody who is in your shoes as a litigant chose the cheaper version. You know who doesn't end up a litigant? The people who don't choose the cheaper version. They end up making an insurance claim and getting their money. But the ones who end up in litigation miraculously have always chosen option 2. Now, if you choose option 2, why is it that you're suing for $5,000 when you're limited? Did you not read what you were signing?
Welcome back to the People's Court. So who's moving into the winner's circle? We'll find out right now.
They told me that they were fully insured, door to door, everything wrapped, everything taken care of. That's what I was told. On top of that, Judge,
So?
why would I pay? I was already charged double over double than what I thought I was going to pay. So now you're saying another $1,000. And on top of that, I'm paying a professional company to do a job. If that's the case, then, I mean, I would have done it myself.
Maybe you should have.
He also refused.
But no, excuse me, there's no
Absolutely.
question. There's no question pending. Ms. Gonzalez, hold on. I've been doing this alone my whole life, okay? Listen to me, Mr. Medeiros. You made a gamble, and when you make a gamble, there's a chance you're gonna lose. So why should I pay another $1,000? No problem. Lo barato sale caro. The cheap comes out expensive sometimes. So you took a gamble and you lost, and you want to pretend you didn't take a gamble? This is your contract.
No, I don't want to pretend, ma'am.
This is your contract. This is your contract. In your contract, you say, I waive my right to sue for anything other than 60 cents a pound. So I'm holding you to your contract. I see a broken TV. I know it happens sometimes. I'm ordering Ms. Gonzalez that you can put this through with your claims people or however it works, that they in fact pay the $144 that they offered him. That's my verdict. Good luck, folks.
Thank you.
Thank you, Your Honor.
Stick around.
So the plaintiff fails in his lawsuit, and he's held to what he signed in the contract. I wonder what his decision is and how it's bothering him. Let's find out. Mr. Medeiros, how do you feel right now after the judge made her decision? What are you thinking?
I mean, I don't know how you pay a company $4,000 and then they make $5,000 worth of damage. You're talking up to $9,000, and I'm going to get $144 back. It's kind of slap in the face.
Well, unfortunately, you got to live with it because you signed that contract. There's not much you can do now. You understand that, don't you? The judge's hands were tied.
I understand that.
All right, I'm sorry for you. I know you're not happy. I wouldn't be either. All right, Ms. Gonzalez, does this kind of thing happen a lot? The judge seems to think a lot of people always take the cheaper option. Is she right?
They do. They do. And a lot of people refuse packing materials, and, you know, we just have to wrap it with a regular blanket. It's going cross country. It's going on several trucks. Things may happen. That's why it's highly suggested to get extra insurance.
All right, well, congratulations. Thank you very much. All right,
Thank
let's see what the judges
Thank you.
think
It was a
about
pleasure.
this. And here they are. Time for another session of After the Verdict.
Every time you enter into a contract, Marilyn, you're gambling. You're gambling on one end, I'm gambling on the other end, that you're going to be able to provide certain goods or services, and I'm going to be able to provide the money at the moment of truth, etc. And it's no different with a moving company, right?
Right, but you know, buy the insurance you intend to enforce.
Right. When you go into that moving company casino, you have a choice. You can take option A or option B. And option A is kind of crappy when you only get 60 cents a pound for stuff that gets damaged. But the reality is when you move, stuff's gonna break.
Yeah.
The house you're leaving is gonna get damaged. The house you're moving into is gonna get damaged.
It's not a perfect world.
A bunch of your stuff is gonna get broken. In fact, you and I just moved our 3 daughters from Miami to DC last month.
And we did it ourselves.
We did it ourselves.
We did it
People thought I
ourselves.
was nuts, and you were nuts.
Yeah,
but
the kids were whining about it too.
This
but-
is why. And
Right, but in this case, he ended up complaining that he had to get it. He mismanaged his move, either on purpose or through incompetence.
Right.
He mismanaged the quote. So he really has nothing to be angry about in trying to recoup it on the other end. And that bed that he was showing was not worth the kind of money that he was asking either. Not that it matters, because at the end of the day, it's the contract, the contract, the contract.
Absolutely. And hey, moving is either the American adventure or the American nightmare.
Right.
So sometimes it's a little bit of both.
So Lori wants to know this. Hey, Harvey, if somebody gets hurt on my porch, are my husband and I responsible to pay all the medical bills? Well, not if you're not negligent, Lori. If they trip over their own feet, you're not responsible. If, however, the porch isn't level and they hit something that they couldn't have seen, then you're going to be on the hook. It all depends on negligence. See you next time.